Hello everyone, I'm back to do a civil procedure lecture, and this one's going to contain venue, notice, and choice of law. Okay, venue, notice, and choice of law, and this is civil procedure video number 3. I did PJ and I did SMJ so far, and this is venue. Okay, so venue, let's go over venue. Concerns which geographic district is the proper place for a particular case to be heard. So venue is important for, I've seen it on essays and MBEs. Now, when is venue proper? Venue is proper where the claim arose or where the defendant resides. So we're going to do claim arose first. So for federal court, where the claim arose, injury occurred, or the contract was entered into, or where the land in dispute is located. I've seen this on MBEs. So if venue is proper where the land in dispute is located, okay? And also where the contract was entered into and where the injury occurred. Now in California is a little bit different. Proper in the county where the claim arose, because there's different counties, county A, county B. Injury occurred, or where the contract was entered into, or where the land in dispute is located. Same thing, just that they have more counties. Okay, so federal and California are pretty much the same. Venue proper, it's also proper where the defendant resides. In federal court, proper in any district where any defendant resides, any defendant. California, proper in a county where any defendant resides at the time the case is filed. Important for California, at the time the case was filed. Now, transfer of venue comes up a lot too. Now, original venue was proper, but so for some reason they want to transfer the venue. In federal court, venue may be transferred to another federal court where the case could have been filed or all parties consent. These are important elements because I've seen these on MBEs. Where all parties consent, and there is proper, PJ, SMJ, and venue. So remember, if you get a venue question, is the venue proper? You're not just going to write about venue, you're going to write about both of these. Depends on what you're going for, SMJ or PJ, okay? And then you go into venue. California, federal, so we have federal and California for venue, which is essays, not MBEs. California, the venue can be changed at the judge's discretion, where the interest of justice and convenience of the parties would be served by such a transfer. Okay, a little different there. So original venue, improper. So at this one, the venue is proper, very important. Now we're going to go, what if the original venue was not proper? Okay. Federal, the court must dismiss to a proper venue where the case could have been brought, and there is PJ, SMJ, and venue. Remember, you have to write all these up, not just venue. Improper venue can be waived by the parties. So if all the parties agree and say, you know what, it's fine, we're fine with doing it in this court, then it's waived, and it's allowed to be waived. In California, transfer of venue to proper county when the court designated in the complaint is not the proper court. Okay, that's California. Distinctions there. Forum nonconvenience. We have federal. A court may dismiss or stay a case if there is a far more appropriate forum elsewhere, such as another state or country. Okay, federal court. In California, they're going to balance the public and private factors. Public, what law applies, which community should be burdened with the jury service, and private, convenience, location of witnesses, and evidence. Okay, public and private, different distinctions there for California. Okay, now let's go to notice. Notice, defendant must be properly notified by a pending action by a reasonable method and must be given an opportunity to be heard. Okay, that's our notice. Oh, notice of the actual, you know what, this is important. So a defendant must be properly notified of a pending action by a reasonable method and must be given an opportunity to be heard. I get a lot of MBEs on these. These are service of process. And basically, there's distinctions for federal and California. So was the defendant properly notified by a reasonable method, and was he given the opportunity to be heard? Okay, this is very important notice. This is part of our write-ups too for our essays. So this goes to SOP, which is service of process. Summons and a copy of the complaint is what they must get. Now the methods of service, can be made by anyone who is at least 18 years old and not a party to the action. Okay. Personal service is always okay. There's a distinction with California about that, though. Substitute service is okay with federal court, can be left at the defendant's usual abode and served upon someone of suitable age and discretion who resides there. Lots of MBEs on this. So someone of suitable age, doesn't say 18, it's a suitable age and discretion who resides there, or served to the defendant's agent, or served by methods permitted by state law. Okay, so this is all for federal court for substitute service. So personal service is okay, but if it needs to be substituted, this is how we do it for federal court. These kind of have to be memorized for, these are really a lot on MBEs, okay, and that's a federal court. Now remember, we only need to know federal court for MBEs, but we need to do California for our essay, so let's do California now. Of course, California is different. California substitute service, so of course we have personal service is okay, but if they cannot do personal service with reasonable diligence, they have to give a reasonable reason why they couldn't do personal service, then they may use substitute service. It must be left at the defendant's usual abode with a competent member of the household who is at least 18 years of age. All of these elements need to be met, and the person must be informed of the contents. The server must then mail a copy. Now we're going to have to mail a copy of the papers to the other party at the address the papers were left. Okay, and I believe there's a, I've seen a couple of essays on this where it has to be certified mail, I believe. So you might have to look that up, but I've seen an essay about the mailing of it, how it was mailed. Corporation, I believe it was. Here we go. California corporations. Service of process may be made on defendant's agent or one apparently in charge at the office during his usual office hours. So that's for a corporation. Okay, so this is service of process for California only. My other slide was federal. Make sure you know all these elements, and a lot on MBEs. You do a lot of them, then you'll be able to memorize them. Let's see what we have next. Choice of law. Now we're going to move into choice of law for diversity action, which is the Erie Doctrine. Very important here. We have a lot of MBEs on this too. Erie Doctrine, a federal court sitting in diversity, so you have to make sure it's diversity, not federal question. Okay, so diversity must apply the state substantive law, and that includes statute of limitations, state's conflict of law rules, and federal procedural laws. Now, they're going to apply state substantive law, okay, but they're going to apply federal procedural law if it's going to be a diversity federal court action. Okay, so procedural law. You guys can look up what that is. This is very important for MBEs, but state substantive law like statute of limitations, okay? If it is unclear if it's substantive or procedural, then the judge will use the test, the outcome determinative test. If it is substantially affects the outcome, then it's going to be substantive. Federal interest versus the state interest you also balance. If state has a greater interest in it, then it is substantive. Okay? So these are all on MBEs too. That's Erie. California Erie rules. Choice of law rules for California. They are deemed substantive under Erie. If it's a tort action, comparative impairment to each state's interest in having its own law applied. So we're going to argue both states' interest in having their own law applied, and you're going to pick the best one. If it's a contract action, depends on whether there is a COL in the contract, COL in the contract, so a choice of law in the contract. If there's actually a choice of law in the contract, we're going to use that one. If not, you're going to do the same thing you do with tort actions. You're going to use the comparative impairment test to each state's interest in having its own law applied. We're going to argue that. Now, without the COL, or use comparative impairment, if it does have a COL, there's no conflict, but there's no conflict, reasonable basis, and does not conflict with California policies. If there is a conflict, California has materially greater interest, then the California law will be applied rather than the other states. Okay, so usually California wins with their laws. And that's pretty much all this lecture is. So basically, these are the smaller, kind of the little in-betweens, venue and transferring of venue, forum nonconvenience, notice, and service of process for California and for federal. Again, know those. And then the choice of law, Erie. So these are kind of minor issues that we have to put in our essays, a real quick little, I would assume it would be like a little paragraph or so. But these are big on MBEs. I've seen a lot of them on MBE. So if you know these really well, all these rules really well, you do really well on your MBEs. So just do lots of MBEs on them. This was venue, notice, and choice of law. And I'll see you guys on my next video.